couple of points I wanted to add. We had a question earlier about whether or not there was a sample RESPA letter in the materials, and my answer is kind of. On page 163, there is the letter, a copy of the letter that I wrote, and actually it's not a RESPA letter formally because it was addressed to the law firm that had been representing the mortgage servicer in the bankruptcy, so I had a lawyer contact, so I wrote to them. And I mentioned the FDCPA, the Fair Debt Collections Practices Act, in this letter rather than RESPA, but this as a sample of a request regarding a dispute with a servicer, this could have been a RESPA letter as well. I wanted to review, by my count, we're discussing 4 different laws that place a requirement on the mortgage servicer to respond to a request for information. We've referred to RESPA quite a few times. That's the primary source for the requirement for a mortgage servicer to respond to a request for information or to resolve a dispute. So RESPA requires a servicer to respond. As a practical matter, many servicers will hold off taking further steps towards foreclosure while they're resolving that dispute, but the statute itself doesn't require it. So there is the requirement for servicers to respond, not a firm requirement that they hold off on foreclosure while they're responding. We mentioned the Truth in Lending Act's requirement that a servicer identify the owner of the loan in response to a request. The Fair Debt Collections Practices Act also has a requirement that a collection agency a debt collector respond to a request for information. That will sometimes cover mortgage servicers. On page 161 of the materials is an excerpt from the FDCPA that sets forth the requirement for the debt collector to respond to a request for information and a request, a notice that the debtor is disputing the debt. The FDCPA exempts most mortgage servicing situations because it exempts situations where the servicer of the debt got that servicing contract when the account was not in default. And that covers servicers, mortgage servicers, who began servicing the loan right from the beginning because it wasn't in default at that point. But there is a provision that the FDCPA will apply if the servicer obtained the servicing rights after the loan was in default. So FDCPA will cover mortgage servicers in that situation, which is why I mentioned earlier it's a good piece of information to get from your client whether or not the current servicer of the loan got the account when it was already in default. FDCPA has a clear requirement that if you send a letter disputing the debt, no further collection action can take place while that dispute is being resolved. So it's a clear way to stop, under a legal requirement, any further collection action, including the filing of a foreclosure. So if you can use the FDCPA, if you can reference that in your letter requesting information, that's a very useful thing. And the fourth source, there's a provision in Act 6 in Section 404, and again, Dan is going to talk about Act 6 in detail, that requires that fees and costs related to foreclosure be put in writing. And I have used that in my letters as a source for a requirement that they respond and explain further the fees that they're seeking to collect. So, for example, in the case of mine that's in the materials at page 157, there's the Act 6 notice that lists these default expenses and fees, and my letter back to them raised the FDCPA because it was in default when they got the servicing, and Act 6 because I wanted clarification of what these fees and costs were, and under Act 6 the homeowner has a right to a written statement of the fees. Any questions about any of the materials that we've talked about so far on servicing? Yes.
Does the Pennsylvania equivalent of the FDCPA, the crazily named Fair Credit Extension Uniformity Act, have a similar requirement to the one you just mentioned about a credit or a debt collector not pursuing action while a dispute is being resolved?
It's a good question. I believe that it does. It also has the same limitation that it wouldn't apply to a mortgage servicer unless the loan was in default when the servicer obtained the servicing rights. It has a further exclusion. It doesn't apply to purchase mortgages. So if your servicing dispute is with your purchase mortgage, the state debt collection statute doesn't apply.
Dan, just one thing. I want to just show a quick slideshow just for a moment,
Sure.
relating back to my discussion about the various government bailouts. So, if you'll humor me for a moment. This is the TARP program that we've heard a lot about. Oh, I'm sorry. Get myself set up here. There you go.
And TARP, of course, being the Troubled Asset Relief Program.
This is to help bail out some banks.
You wouldn't know that Mike is from Ireland, would you? That's where this happened, wasn't it, this little scenario?
Yeah. So they bring a bigger truck in to help out. And of course, that doesn't work out too well either. Thank you.
Thank you for that, Michael.
I had a question for Patrick. If I'm not mistaken, the attorney fee provisions of Act 6 are mutual. That is, they apply to prevailing parties. Is that correct?
One more time?
The attorney fee provisions in Act 6 provide for the payment of fees to prevailing parties. And I was wondering if there would be any impact in that provision on the scenarios when you're actually disputing the propriety of the imposition of a fee by a mortgage servicer.
So your question is whether or not
You get attorney's fees.
yeah, I mean, I don't know because I don't pay attention to attorney's fee provisions because I work for an LSC-funded program, and although we could, maybe refer some of those things out, I don't know the answer to that question, Joe. I don't know, maybe Beth does.
Well, on a practical level, if I understand the question, would I refer in my letter disputing the fees that they could be liable for attorney's fees if they don't work this out quickly? Yes, I certainly would mention that in my letter disputing the fees, that they could be subject to an action under Act 6 and that they could be liable for attorney's fees.
So should we talk about Act 6 now?
I think we should.
All right, Act 6 is the pre-foreclosure statute in Pennsylvania. Sorry for the hoarse voice that I have here.
And let me say that at page 169, there was a beginning at page 169. There's a summary of the provisions of Act 6.
Now, originally Act 6, it was Act 6 of 1974, and originally the amount of the loan that this would apply to had to be $50,000 or less. In September of 2008, the legislature amended this figure to $217,783. So if you have somebody with a loan, the principal amount being $217,700, let's say, or lower, then the provisions of this act apply to it. And by the way, there's an escalator clause in this statute, so it's possible that, although not perhaps in this market that we're living in today, but it's possible for this amount to rise.
And just to make it clear, the servicing provisions of Act 6 apply retroactively as of September 8th. So if a loan that was originated 10 years ago at $200,000, the servicing provisions of Act 6 wouldn't have applied before September of 2008, but they do now, even though the loan was originated before the change in the Act.
So we're going to be talking about two notice provisions. One is the Act 91 notice, and John has been talking about that previously, or referring to it. That's what he's about. But this is just a normal pre-foreclosure notice. And it's to alert the homeowner that they are in default and that they are in danger of being foreclosed upon. It has to be given at least 30 days before, or I should say that the loan must be at least 30 days in default. And the notice has to be sent by certified mail. And it also has to give the homeowner the notice of a right to cure. And the right to cure is the amount that's in default. And we'll talk a little bit more about what's in default. Now, if the loan amount, the principal amount, exceeds $217,783, there is still a possibility that the effects of Act 6 would still apply. Because you want to look at the mortgage documents, there may be a provision in the mortgage itself that requires the lender to give this, in effect, an Act 6 notice, despite the fact that this might be a $300,000 principal amount notice or more. The other thing I wanted to mention is that very cleverly the Pennsylvania HEMAP people put forth a model Act 91 notice, which is required. And what they did was they combined, in effect, the provisions of Act 6 with Act 91. Well, what is covered by an Act 6 notice? First of all, you have to have a security interest in residential units, 2 or less. So a duplex could be included as requiring an Act 6 notice if it's 2 or less units. It also applies to land installment sales contracts or condominium units. What is not covered are loans that are guaranteed by the federal government, either mortgages held, an FHA mortgage, or a mortgage that is held by the Farmers Home Administration, which is now referred to as rural development. However, Act 6 does apply to a loan that is insured by the Veterans Administration. Well, when we talk about a default, what kind of defaults are we talking about? Well, first of all, of course, a monetary default. Also, in the event of a due-on-sale clause, in other words, the mortgagor has sold the house to somebody else, and that person is the record owner. Well, excuse me, the provisions of the mortgage may trigger what's called a due-on-sale clause. It says everything is due upon the sale, and the new owner has to pony up the money. However, the new owner has a right to an Act 6 notice. A famous case of this that covers this is a case called Mara versus Stocker, which is a Pennsylvania Supreme Court case from 1992. Well, what about if the mortgagee sues, or the mortgagee is the lender, what if they sue simply on the note? If the mortgagee sues on the note, but they intend to sell the house to pay off the arrearage, then the Act 6 notice is due to the borrower. If they only intend to sell personal property, no Act 6 notice is required. Now, I said that the notice has to be sent by either registered or certified mail 30 days before any legal action is taken. What kind of requirements are we talking about for the Act 6 notice? First of all, it has to be set forth in clear and conspicuous language, the statement of what kind of security interest is involved or obligation, the nature of the default, the homeowner's right to cure and what amount is necessary to cure, and how the homeowner's ownership will be terminated in the event that this case goes to foreclosure. It also has to set forth the homeowner's right to transfer the property subject to the subject to the security interest, and the transferee's, the new owner's right to cure and not to cure, but to refinance the mortgage. What does it take to cure under Act 6? First of all, the homeowner has to tender the amount due by certified check, cashier's check, or cash. What must be paid? First of all payments due up to that point. That means the principal and interest due up to that point, and the reasonable fees and costs actually incurred as authorized by the mortgage itself. The reasonable late charges under the contract, reasonable attorney's fees. And this gets to be an issue that comes up fairly frequently because, Act 6 says that the attorney's fees must be not only reasonable, but also actually incurred. How long do you have to make the cure? You have actually up to 1 hour before the sheriff's sale. However, I've never seen a case where a mortgagee has turned down payment within minutes of a sheriff's sale. The other thing, excuse me, sorry for the hoarseness in my voice. The other thing that's important...
And sometimes even the next day, Dan.
Yeah. The other thing that's important to realize is that if the homeowner can't tender the Act 6 cure figure before the sale, perhaps this can be done through a Chapter 13 bankruptcy if you file prior to the sale. In other words, a Chapter 13 bankruptcy would extend the period for repayment beyond that date of the sheriff's sale, so long as the sheriff's sale doesn't take place and the hammer falls, and can stretch it out for another 3 to 5 years. Now, that's important for you housing counselors to keep in mind. That if you have somebody that comes in that's not able to make the payment, the cure payment, before the sheriff's sale, but has sufficient income that maybe they can make a Chapter 13 bankruptcy work, you better refer them quickly to somebody who does Chapter 13 bankruptcy work. All right, so up until the time that a complaint is filed, as we just discussed, the fee that is allowable is only $50. After the complaint is filed, then we're talking about fees that are reasonable and actually incurred. A gray area involves things like inspection fees and title reports, and that's a gray area because there's been litigation on those issues, and the litigation, frankly, has gone both ways. Okay, any questions at this point about Act 6? Any comments from the panel?
I don't have any specific comments about anything that Dan said, only that you won't sometimes you'll see the notice will say Act 6 notice. I mean, if the person comes in but because PHFA created a joint Act 6, Act 91 notice, it won't just maybe be glaring that it's this Act 6 notice. And so it's just really, really important to look at those notices and examine those fees to make sure that there aren't any other fees that are added on that, especially this, more than $50 in attorney's fees that are added pre-foreclosure. So it's important to analyze, those notices to make sure that the fees are explainable, reasonable, and make some sense given what the homeowner's telling you their situation is.
Yeah, we look at, when the agency combined the Act letters, the 6 and 91, we look at that as any loan now at under $217,000 that is conventional or VA would get a combined notice. The only time you're really going to see an Act 6 anymore is on FHA insured mortgages. Used to be under 50, but now, of course, under the new 217 number. So that's our rule of thumb. If it's FHA, you're going to see the Act 6 notice, and it will be titled Act 6 probably.
I made a mistake. I said that Act 6 did not apply to FHA mortgages. It does. Act 91 does not, Homeowners Emergency Assistance Notice does not apply to FHA mortgages. So, should we move on to Homeowners Emergency Assistance, which is commonly called Act 91? Basically, this is a program set up by Pennsylvania legislature to rescue people who are in default through no fault of their own, who have a reasonable prospect of repaying, originally after 24 months of assistance. But now that we're into an era of high employment, we're talking about 36 months of assistance. High employment is over 6.5%.
High unemployment.
I'm sorry, high unemployment. 6.5% of unemployment. This is a statute that is supposed to be liberally construed. However, there's a caveat to that, and that is that the agency's interpretation of the regulations by the courts is entitled to great weight. The coverage is for any mortgage, and that's defined as an obligation evidenced by a security document and secured by a lien on real property in Pennsylvania. Now, that includes a land sales agreement, an agreement securitizing a condominium or a cooperative apartment, or the land under owner-occupied mobile homes. In other words, the mobile home owner has to also own the land under the home. In addition to that, it must be the person's principal residence and limited to 1 or 2 units. Again, a duplex qualifies. A 1 or 2 unit duplex would qualify. Not covered are FHA insured mortgages, Title II mortgages, rural housing services mortgages, and certain other turnkey federal mortgages, insured mortgages. And why is that? It's because those mortgages have their own insurance programs. Now, essentially, we're talking about the lenders who are in the business of loaning money. We're not talking about Uncle Harry who has loaned the money for somebody to buy their house. However, if Uncle Harry decides that he would be willing to submit to the Act 91 program, then he can voluntarily agree to be part of the Act 91 program and be paid accordingly. Okay, so some limitations on eligibility. First, the borrower has to be no more than 24 or now 36 months in arrears. The arrears cannot exceed $60,000. there can't be more than 2 mortgages on the property unless the third mortgage is a PHFA mortgage. If the homeowner is in bankruptcy, it used to be that you could not apply until you got relief from stay. Now that prohibition no longer applies, and even if the homeowner is in bankruptcy, you can apply for Act 91 assistance. Okay, what about the notice? The notice has to be given to the homeowner at least 60 days after a delinquency is incurred and before any legal action can be taken. This notice must be sent by regular first-class mail. And the model form that's set forth by the Pennsylvania Housing Finance Agency as Exhibit A in their regulations is the form that has to be used. You know, the question comes up in both Act 6 cases and in Act 91 cases, what happens if the homeowner has not gotten this notice? The argument is that the court has no subject matter jurisdiction to proceed with the foreclosure action. And if the homeowner has not gotten the notice, then you as a counselor want to make sure that that homeowner gets to an attorney pretty quickly, or you can inform the lender that your client has not gotten the notice. It's in the lender's best interest to give the notice because the lender has an opportunity to be paid the arrearage. Okay, once the homeowner receives the notice, we have 3 time triggers that are very, very important. First of all, the homeowner has 33 days to get to a counseling agency and a meeting with a qualified counseling agency. Now, the notice itself has to have, as an appendix to it, a list of the counseling agencies in the county, or for the county, I should say for the county, where the homeowner resides. If it doesn't have that list, then arguably the notice is deficient, and once again, the court would not have subject matter jurisdiction to proceed with a foreclosure action or to entertain a foreclosure action. Now, what if the homeowner has missed the 33-day initial period within which to apply for counseling? You still want to have the homeowner apply for homeowner's emergency assistance. However, the mortgage company, the mortgagee, can now proceed with a foreclosure action. But nevertheless, if Pennsylvania Housing Finance Agency will probably entertain that application for homeowners assistance, and if it is granted, then you can ask the mortgage company to stay the the foreclosure proceedings so that they can be paid, so that the rest of the process can go forward. All right, so 33 days within which to arrange for the mortgagor, the homeowner, to arrange a counseling session with a qualified counseling agency. The counseling agency has 5 days then to notify the mortgagee that the homeowner has come in and requested Act 91 assistance. Then the counseling agency has 30 days within which to forward the application to Pennsylvania Housing Finance Agency. The agency then has 60 days within which to consider the application and to either approve or disapprove the homeowner's request for assistance. During this entire period, 33 days plus 30 days, as long as each of the time deadlines is met, the mortgage foreclosure action, any mortgage foreclosure action is stayed, is put off. Okay? Only after this period, if the request is refused or turned down, may the mortgage company proceed now to a foreclosure action. What are the qualifications for the homeowner for assistance? First thing, obviously, property has to be located in Pennsylvania. The homeowner has to be a resident of Pennsylvania. Second thing, the homeowner has to be in trouble through no fault of his or her own. What are we talking about? Job loss, a family problem, let's say divorce, separation, reduction in hours of employment, something that we see a lot of now, illness or death in the family, an increase in the escrow payments, or a reduction or delay in government benefits. Let's say that there's a problem with a person's Social Security checks. That's the first prong. The second important prong is, so situation arises through no fault of the homeowner's own. The second thing is that the person has a reasonable prospect to resume mortgage payments after 24 months or now 36 months of assistance. And as I said before, no more than 2 mortgages or liens on the real estate, except for, let's say, a PHFA lien mortgage. A couple major detriments. First of all, the circumstances in which the mortgagor finds himself or herself are not beyond their control. There's been financial mismanagement, quitting a job without good cause, or being fired for misconduct, or having a prior bad mortgage history. The other issue is not able to resume payments within 24 or 36 months. What I try to do in these situations is, if I've got somebody with a good work history, even though the market is in a very bad situation, it doesn't appear that this job, what this person has done, is available. Let's say that they're a machine press operator. What I try to emphasize is that this person has a long work history, is serious about their work, and is maybe in a retraining program. Usually this comes up in the context of an appeal from an adverse decision. But it doesn't hurt, if you're the mortgage counselor, to make sure that that this kind of information gets to Pennsylvania Housing Finance Agency. You know, mortgagor has 20-year history of steady employment, lost job when factory closed. Even though machine press operator is not a job that's on the market right now, this person is serious about getting other employment and is trying to get retraining. If this is for the lawyers out there, and for the counseling agencies as well, I guess, if your client loses and is turned down for homeowners emergency assistance, and you think that they have a shot at getting assistance if they take an appeal, be sure to urge them to take an appeal of the adverse decision. My own experience is that I've had a fair amount of success in taking appeals if I can put the right facts in front of the hearing officer for PHFA. If you're going to take an appeal, you've only got 15 days from the date of the postmark on the initial decision turning you down. So make sure that you get on your horse if your client has gotten an adverse decision from Pennsylvania Housing Finance Agency. Okay, I think that covers the waterfront. Comments or questions?
Dan, you had mentioned that a homeowner may apply for Act 91 assistance while they're in bankruptcy. So if a lender or lender's attorney sends an Act 91 notice while a bankruptcy is pending, does that violate the automatic stay of the bankruptcy code?
I don't think so.
I'm just looking for free legal advice.
Yeah, I don't think so. I'm certainly not going to raise that as an issue because I want my client to get Act 91 assistance, and I want to maybe cure this thing so we can get out of bankruptcy.
Let me add a couple comments. To answer Mike's question, in an effort to try to get around that, we put in the guidelines itself a statement that says that sending of the Act 91 notice while they're in bankruptcy, in our opinion, is not a violation of the automatic stay. Now, whether it would be a violation to a bankruptcy court judge, that's another question. But we tried to at least sway them in that direction by putting that comment in there.
Well, for it to get to a bankruptcy judge, somebody's got to raise that and I certainly am not going to raise that as representing the person who's in bankruptcy because I want to try to get my client all the help I can.
And we've never had a decision from a bankruptcy court judge I'm aware of that has addressed that. What we require is if a person's approved, then there has to be a stipulation entered into between the bankruptcy attorney, the client, and approved by the trustee to allow them to incur our debt, since it would be new debt. And everybody's on board usually with that because it's the best deal for the homeowner. One other comment I wanted to make on Dan's reference to 36 months. When HEMAP was first passed back in 1983, 36 months of assistance was possible. It was, in some people's opinion, a very generous amount of time because 36 months is 3 years. I mean, a parent wouldn't pay their child's mortgage for 3 years, probably. As the expense of the program back in 1998, I think it was, some amendments were made to try to limit the cost of the program. The $60,000 cap, the no more than 2 mortgages that we can assist on, and then the third thing was to put in what we call triggers, and it reduced the 36 months to 24 months. It also reduced increased from 35% to 40% the amount that the legislature thinks is reasonable for a person to spend on housing expense. But the trigger is that if in sort of a 3-month look back, if for the past 3 months the unemployment rate is an average of 6.5% or greater, then applications received in that next month would trigger up to the 36 months and back to the 35%. Now, it also says that the agency has to announce that, okay? As of Friday, it hadn't triggered yet because the Bureau of Labor Statistics weren't out last week. But I'm told today by Don Moritz that they are out now. Is that right, Don? And apparently it has ratcheted up so the average is above 6.5 for the past 3 months. So we haven't made an announcement yet. We haven't published a notice yet. Probably will be very soon.
And John, just to be clear, is that for both continuing and non-continuing, the 36-month period?
Yeah. Well, yes, it would be.
Okay, and so everyone's clear that there's two kinds of assistance from HEMAP. There's non-continuing and there's continuing assistance. Non-continuing is the kind where you're behind, presumably for as much as 36 months soon, and HEMAP will pay that amount to get you caught up. And you can show that you can maintain maintain your mortgage payments going forward. And then there's continuing, where they'll actually, help make some of those payments for a period of time. Did I accurately describe that, John? Or you
yes.
want to add to that? So if look for some notices soon, perhaps in the Pennsylvania Bulletin. Is that where they'd be published? Where you would publish your notices?
We would publish in the Pennsylvania Bulletin, and there's sort of a gap in terms of we have to get a notice to them at least 10 days prior to the publication date, which is every Saturday. So even if we did it tomorrow, it wouldn't appear until next Saturday, not this coming Saturday, the following Saturday. The other thing I want to mention on 36 months, the triggers, it's a monthly look back. So from now on, every month we'll look back 3 months and see what the average was. So that loan applications received in that month will have either the higher or lower triggers applicable to it. It gets a little complicated. We haven't had to deal with this since the provision was put in 1998. So it'll be fun for the next couple of years, I'm sure.
I hesitate to add to or anything that John has to say, because if you look at HEMAP decisions, his name appears on virtually every single one, and he knows the program backwards and forwards. But I wanted to just say a couple of things. First of all, I'm not sure if Dan, you talked about 33 days and that a person could still apply after that 33-day period. The amendments to the statute make it absolutely clear that a person can do that. And I think you said that if HEMAP was benefits were alone was approved by the agency during the process of a foreclosure action, that the person could ask the lender to stay. A stay, if I'm right, a stay is mandated. Is that John's nodding yes? So it's required. The stay just is. It happens if benefits are granted at any time before an actual foreclosure sale. Also about circumstances beyond a person's control. That would include. I know that there are some cases where people got into trouble because they had a personal problem, for instance, alcoholism, and I think there are a couple of cases which talk about that as long as a person's getting appropriate treatment, that the court will look favorably on that and will consider that to be beyond their control. John's again nodding. And also to make clear, this is a three-step process. For instance, it's similar to procedurally like unemployment benefits, where you make an initial application, there's a determination, an initial determination, and then you can make an appeal to the agency. The agency makes a final administrative decision, and then you can appeal further on to Commonwealth Court, as you can any administrative agency final decision.
Yeah, those cases going up to Commonwealth Court don't always go very well. And John explained that to me one time. He said it's not the Commonwealth Court, it's the Commonwealth's court. So I took that as a...
Well, as I said, John was counsel in virtually every one of those cases, and so he knows what he's talking about. But
I have distributed some questions to the panel that have come in from some other places, and I do want to mention a couple things that I might speak to while they review those. One of them had to do with this RESPA letter issue, and I just wanted to mention also, there is the one piece in the materials that Beth referred to, but also Michelle Lewis has been kind enough to say that she is going to share with us the more extensive RESPA letter that she has developed. And you'll recall at the very beginning of today, we talked about some materials that are posted on the website, and we'll make sure that that is available too. So if you go to the home page of the PALegalAid.net website, you'll find the materials for today's training, the Obama materials on mortgage foreclosure. You'll find that RESPA letter. And as I heard today's discussion, I'm just going to add one other thing there too, which is the materials that come out this week, I guess that add more substance to the Obama proposal. We'll make a point of posting those too. And there were a couple questions that followed up on an earlier session. There's a question asked, is attorney-client relationship formed by homeowner leaving a message on a hotline of a legal services organization? And I think the answer to that is pretty easy. You go back to this substantive law. There's no meeting of the minds. There's no basis for reliance and so forth. So there is not an attorney-client relationship, although there may be some basis for liability if somebody were harmed by leaving an important, time-sensitive message, never heard back, Of course, we all take risks that we may harm somebody's interests, so it clearly is in everybody's interest to return that kind of message to make sure that the person is being responded to. But I don't think that makes it an attorney-client relationship. And the second part of that question was, what if the homeowner later speaks to a non-lawyer on a hotline and receives legal advice, and non-lawyers who might be doing that, at least in our field, we normally refer to as paralegals under the supervision of a lawyer, and that is an acceptable way of being able to provide advice and assistance. So it is essentially as though they were getting advice from the lawyer. So I don't know if the questioner had more behind that question, but of course it's always important so that it's not unauthorized practice of law that's occurring.
And Sam, that may have been where the genesis of that question came, was just the concern, and it may have been in terms of a project like this which brings lawyers and non-lawyers and people outside of legal offices together working on issues like this. Clearly, there probably are times that some of the housing counselors can get pretty close to the edge of giving legal advice, but I think the point here and the point of our whole project is to make sure that those kind of situations don't happen, that counselors know they can turn to attorneys to get support, that they have attorneys who are just a phone call away if there are questions that need to be answered. And I think we've put some safeguards in place that if that was the concern, the latter concern, it was handled. Obviously, if it's the first concern and it's a paralegal working under an attorney, there is no problem, and if there is bad information given, that's just something that we'll have to correct. Now, we have some other questions, and we've been doling them out among the panel. So I don't know, Patrick, one was specifically for you, so I don't know if you want to take the one for you or just tell them to call you at your office later.
There are two questions that are substantially similar. The question that was addressed specifically to me deals with my reference to rescission under Pennsylvania state law, under the Consumer Protection Law. And the question reads, with respect to Section 201-7 of the Consumer Protection Law dealing with rescission, are you saying if a loan closed at a consumer's home, if the loan closed at a consumer's home and the consumer did not get a separate 201-7 notice of cancellation, that the consumer may cancel his or her loan? And the answer to that question is, as written, no. I'm not saying that if they don't get a specific 201-7 cancellation notice that they can rescind the loan. What I meant to say, and what I will say if it wasn't clear, is that under Truth in Lending, there's a 3-year extended right to rescind your loan if material disclosures aren't given. One of the material disclosures under the Truth in Lending Act is the notice of cancellation. And so if you aren't given that notice, or if it's improperly filled out, or if you aren't given the right number of copies of them, you have an extended window to rescind that loan up to 3 years from when the loan was originated. And what I'm saying is if you have a loan in your house, or if you have a loan that comes into your office, and that 3-year window has passed, but that loan was solicited at the person's residence, or the closing happened there, or there's substantial contacts with the person, in-person solicitation, solicitation by telephone, solicitation and the closing at the house, and they didn't get this cancellation notice at all, the Truth in Lending cancellation notice, that would give rise to rescission under Pennsylvania law, not under the Truth in Lending Act. And so they don't have to give two different notices. They don't have to give a state notice and a federal notice. The state law talks about the content of the notice that's required. It doesn't have a specific, it just talks about the content. And so a lot of that content is subsumed in the federal notice. If those federal notices are given, I think it'd be a tough sell for you to make the argument that they're allowed to rescind the loan if the federal notices were properly given and it's more than 3 years. So I hope that answers that question.
Well, where that situation arises most frequently is with these home remodelers who are coming door to door and soliciting business and doing the loan transaction at the person's home.
And the second question related to that says, what is UDAP? What's the site? Is it the Pennsylvania Unfair Trade Practices Act? Yes. the law in Pennsylvania is the Pennsylvania Unfair Trade Practices Act and Consumer Protection Law. UDAP is a generic name for all of these consumer protection laws nationwide, and it stands for Unfair Deceptive Acts and Practices. The site for that is 42 PACS 201 at SEC, and there's a whole bunch of sections that follow that. And 73, thank you, not 42, thank you. 73. Oh, yeah, it is. And then what's the Door-to-Door Sales Act? It's in the UTP CPL. If you look at the entirety of the UTP CPL, it has a bunch of, there's the puppy mill legislation in there. There's all kinds of stuff, right? John Abel at the AG's office is smiling at me. Am I right, John? It's all subsumed in the UTP CPL. And then the latter part of this question is kind of related. And it says, if a client has good income but having trouble making mortgage payments and property value down, and property value is down, can they refinance to get help? I think I'm reading that right. Sure, if they can find someone to refinance for them, and if it gets into all of the stuff we talked about before, and that is a difficulty of if the property value, if they're underwater and the property value is less than the loan amount, some of the difficulty in actually getting the mortgage, your current mortgage company to write the loan down to that level.
Well, in many of these cases, it's a matter of a good counselor going over the family budget and prioritizing payments. And frequently, you can help somebody with prioritizing, helping them prioritize their budget and cutting out some things like 2 telephone systems, a mobile phone and a landline. Maybe they don't need 2, and maybe they need to cut back on some of the cable charges that they're incurring.
I have one more question from one of the other sites. Is there any traction to the idea that you need to have a 3-day period between the date the borrower gets all the documents and the date when the settlement can be held? And the answer to that is no, there's no traction because there's no requirement. That's, I think, a turning around of the 3-day requirement. There's no requirement that, aside from the HOPA provisions of TILA, which we won't go into in detail, there's not a requirement in general that the essential loan documents be given to the borrower 3 days before closing. This is a reference to the 3-day period under Truth in Lending Act where you can cancel after the closing. So it's 3 days from the date of settlement to cancel, and disbursement of loan funds should not be happening during that 3 days. There really shouldn't be any steps taken by the lender to make this loan go into effect before the 3 days has passed, again, for a loan that's a refinancing, not a purchase mortgage.
Beth, just a quick turn on that. What if this is a home remodeling loan and the home remodeler shows up the second day after the loan transaction has taken place and starts work on the house and now says, wait a minute, you owe me for my work?
That I would say would be a violation of the right to have 3 days to cancel, and that the claim for repayment should not be honored under the Truth in Lending Act requirements. We have 2 more topics to cover. The day is getting late. We're all getting tired. I'm having trouble listening to my own voice at this point. But thank you for sticking through this long day and lots of information. FHA servicing is one of the 2 last topics. On page 273 of your materials, there's a summary of the statutory and regulatory citations that require special servicing for FHA mortgages. Essentially, those servicers who are handling FHA mortgages are required to try to avoid foreclosure. They're required to send notices to the homeowners, letting them know that there are options to avoid foreclosure. There is a set of options that are defined in the regulations that the servicer should consider, and they should consider all of them, including loan modification. And on page 273 are the citations to the regulations for the basic requirement for FHA servicing and each of the different kinds of options, each of the different options to avoid foreclosure. We talked about some of this earlier, the partial claim program, forbearance agreements, deed in lieu of foreclosure, recasting of mortgages, which is the loan modification option. Question arises, how do I know this is an FHA mortgage? The more recent mortgages, if you turn the page to page 274 of the materials, the more recent FHA mortgages actually have a paragraph in the mortgage itself, paragraph 9. It's the acceleration of debt provision that actually refers in Section D to the regulations of the HUD Secretary being applicable to this loan. So that's one way to figure out that it's an FHA loan. Client may understand that it was an FHA loan. Calling the mortgage company should get you that answer as well. Once you know it's an FHA loan, check to make sure the servicer is complying with these requirements. Sometimes the servicer has not made the attempts required to service the loan according to the FHA standards. Or maybe there was one letter that was sent to the homeowner and the homeowner is trying to comply with it, but the servicer seems to be progressing towards foreclosure without waiting for the homeowner to comply. The letter that the homeowner should receive lets the homeowner know that there are these different options and requests information, that the homeowner should be sending in financial information. And you typically don't get a lot of time to do that, but in the FHA servicing regulations, there's not a turnaround time set. So if the homeowner is trying to comply, getting the information together, it's a good idea to let the servicer know that you know this is an FHA loan and that they've got to comply with these requirements. Size up the situation and decide which one of these options might work best for the client. If a special forbearance agreement won't work, if the client can't get caught up on all the missed payments within 6 months, that doesn't mean that the answer is just no. Some of the other options should be considered, and at this point in time, loan modifications in particular should be considered. There is case law in Pennsylvania that establishes that failure to comply with FHA servicing requirements is a defense to foreclosure, so that can be pointed out to the servicer as well, and if foreclosure starts on a case like this, it can be raised as a defense. You can work out these arrangements even after it's in foreclosure. An issue at that point will be foreclosure-related fees and costs. You can argue that the fees and costs shouldn't have been incurred if FHA servicing had been performed as required before it got into foreclosure. The last topic is loan modification. You may well have the experience of a client receiving a loan modification offer, and that offer may come in the form of a loan modification agreement that the servicer uses generally for its clients. If you look at page 189 in the materials, there's a reference to an article citing research on loan modifications, indicating that more than half of loan modifications have been failing. There have been a lot of loan modifications done over the last year, 2 years or so, and many of them fail. The article indicates that the failure rate has to do with the fact that the loan modifications aren't achieving affordable payments for the homeowners. That maybe the new principal balance under the loan modification just takes in all of the arrears and all of the fees so that the amount of debt increases substantially, that maybe the interest rate isn't cut all that much, or maybe it's cut just for a short period of time and then goes back up. Or even if the rate is cut, the amount of debt increased so much that the monthly payment has actually gone up. So it's important on behalf of our clients to review the loan modification terms and advise the client whether or not this really makes sense, especially for loan modification documents that have provisions that release all claims and defenses. The homeowner may be signing a document that releases claims and defenses when in return they're not getting something that's going to provide a long-term resolution to their problems. So if I were a housing counselor, I would want to turn to a lawyer to review these documents in just about every case. We may not have a good alternative for the homeowner. If the homeowner's alternative is we're going into foreclosure and we can't offer legal representation in that foreclosure, I don't know that we're offering a good alternative to signing a bad loan modification. But I think we have to fully inform homeowners what they might be getting into and what they might be releasing. I've seen a lot of different loan modification forms. On page 191 is one of the simplest and I thought most innocuous loan modification forms that I've seen. It's only 2 pages long. You have to pay attention to the cover letters that come with these because often essential information is contained in the cover letter that's not in the modification agreement itself. So this loan modification came with a 2-page cover letter and the document itself was only 2 pages. It's very straightforward. It sets forth what the new principal balance will be in paragraph 1. And in paragraph 2, it sets forth the term. In this case, the term wasn't extended. Sets forth the date of the first payment due under the loan. In paragraph 2A, it actually says that the current due date has been extended from 6/15/08 to 4/09, meaning that under the prior terms, the homeowner was behind going back to June of 08, but that this modification is going to bring it current and make the next payment due April of 09. Paragraph C, it sets forth that past due interest is going to be capitalized and that the modified unpaid principal balance is now going to be $22,300 some dollars. We did notice that the total amount due, $22,000, was not actually the sum of the principal balance set forth in paragraph 1 and the amount of capitalized interest being added. The explanation for that is that in this case, there were some other fees that were legitimately part of this debt, and I decided it wasn't worth trying to get them to send us another copy of this in order to clarify where that extra money came from. But look at the numbers. It's kind of mind-blowing in some cases that the documents can be internally inconsistent about how much is owed and not clear. The interest rate was dropped in paragraph D, which also sets forth the amount of the principal and interest payment. This agreement didn't make it clear that there was no escrow, and it doesn't mention an escrow, and in fact there's not an escrow in this loan, but my client was dealing with the taxes and insurance pretty successfully on her own, so we left it that way. We didn't include an escrow for taxes and insurance. So this is very straightforward, despite that one error, and the cover letter really didn't create any kind of conflict with the loan modification agreement itself. The cover letter did provide, and this is page 193, that there was only a 5-day period to respond to this, and my client hadn't even received this. I mean, there are lots of problems with situations like this. This was mailed to my client, not to me. By the time I found out that she had it, the 5 days had already passed. And if the lender was really pushing at this, we would have had a problem, but in the end, they weren't, so we were fine. We got the information. We got the payment in. We got the signed agreement in. At the other extreme is a modification agreement that starts at page 195. In the end, it was a really good loan modification, but the documentation was a nightmare. There was a cover letter that came with this agreement that contained information that was contradicted by the terms of the agreement. If you look at the first page, about midway down, there's a whereas paragraph that's a single line that says reinstatement amount under the note is $12,700. So theoretically, that's the amount of the missed payments, taxes, insurance, the arrears as of that date. Oh, by the way, just above that, there's a paragraph that releases all claims and defenses. It's a very onerous release language in this agreement. Down towards the bottom, there's a provision for an upfront fee that was due by a particular date. That date had passed by the time my client received this letter. And again, this letter and agreement went to my client, not to me. If you turn the page, there are several very important provisions. The first, with the asterisk next to it, is the effect on pending foreclosure. They're basically saying that if there's foreclosure, we're not stopping it unless you get all this back to us. And if you miss any payments, we can go back without notifying you that we're going back to the foreclosure. Provision for late charges. Late charges will continue to accrue during the pendency of this agreement. Additional fees and costs. There might be more fees and costs that we're not sure what they are, but we can add them in later on. Modification contingency, another couple paragraphs down. This was sort of a trial period. My client was to make the upfront payment and then 4 or so monthly payments, and then they'll do the loan modification. So this is really a forbearance agreement that's a precursor to a loan modification. But the loan modification, it was clear that that's what we were going for. It does refer to the fact that there's going to be a loan modification, but it's contingent. On the next page, page 197, there's an asterisk by a section that refers to the adjustable rate note. It says that the adjustments in the note the note rate are still going to happen during the pendency of this agreement. And if that were really the case, and how were we ever going to track how much was supposed to be paid under the agreement and what was left to be paid? Then there's an addendum on page 199. There's an addendum to this, which has a whole section, paragraph 3 on page 199, again saying that there might be a whole lot of fees that we're going to add on later that aren't included in this. So my client, we went back and forth on this. He did sign a version of this and made all the payments that were required. And when he got to the end of the trial period, we got another document. And that's on page 201. It was a cover letter with the actual loan modification. The cover letter makes it pretty clear what the principal and interest payment is going to be under the loan modification, and that there's going to be an escrow for taxes and insurance, so that the total monthly payment is $397.85. But when you look at the loan modification, it doesn't really make it clear. It never mentions a monthly payment amount in the loan modification agreement. In fact, it does refer to 387.02 being the payment PITI, which, if you know the jargon, that stands for principal, interest, taxes, and insurance. But it doesn't make it clear how much is the principal and interest and how much is the tax and insurance escrow. Paragraph 7 in the actual loan mod agreement says that the rate is being dropped to 5%. On the back, on page 204 of your materials, paragraph D again says that there are no counterclaims or defenses. And paragraph 10, just in case we missed it in any of the earlier documents, there's another waiver of all claims and defenses. This is the kind of document that it would be really dangerous for a homeowner to sign if they weren't getting a good deal. In the end, my client signed this because we were getting a really good loan modification. It reduced both the principal amount and the interest rate, and it was a fixed. It wasn't ever going to go, it wasn't going to adjust ever. But these are the kinds of what I would call traps that are in these loan modification form agreements that a housing counselor can't be expected to figure out. And there's a great need for a lawyer to look at these documents. And I'm not casting aspersions on any particular servicer. Again, this was a good loan modification. It's just that the form was horrible. So cautionary tale, look at these documents carefully.
Beth, were you able to get some of the onerous provisions of the forbearance agreement out? That the forbearance agreement preceded the loan modification, so were you able to, in the context, I would assume in this case of litigation, were you able to get them to remove some of them? Or?
I crossed them out and sent it back to them, and they didn't complain. So I can't promise that that will always be the case. But we removed them. in a one-sided, non-meeting of the minds kind of way.
All right. Well, thank you very, very much to our panel. We're at the point where we're about to wrap up. It's been a long day with a lot of incredibly important information and materials to digest. Sam, there's a few points we need to do in closing, and I'm going to throw the microphone over to you.
Great. I just wanted to wrap up and first thank everybody who's been in attendance here and at the 4 sites. It's really been a very strong showing for this, and we really appreciate everybody who's turned out. And maybe I should say, especially in Philadelphia, because I know it was particularly a challenge due to the weather there for people to come out, and we appreciate people's support. And I do want to thank, you've met a lot of people during the course of the day, Beth and Patrick and Dan and Michelle, David, John, Samara, and Michael. And I just wonder if we could, not everybody's still here, but most trainers are, if we could just give a round of applause for all of them. And on the subject of thanks, again want to thank Dick McCoy and the Pennsylvania Bar Institute for their generous partnering with us in this project. It's been a first experience for us to do this simulcast. We couldn't have done it without the PBI's help and their ability to make this truly affordable to us. So thanks very much to the PBI. A couple of things about next steps in this project. There are a number of pro bono lawyers who signed up for this training who agreed, okay, I'm going to participate in this training. I agree to take to take 2 pro bono cases in the housing area. And so what we will be doing is forwarding those names back to legal aid programs in the communities where those lawyers are from, and they will be connecting up with the lawyers. We've already identified some truth in lending issues with a lot of math, and we'll make sure to get those to the pro bono lawyers. We know that under this project, referrals are already beginning to be made, that housing counselors are making referrals to lawyers, to the programs in need of legal help. It started more in some areas than in others, but it's definitely no longer a situation where we're just talking in theory, but in fact, in practice, the project is now underway. I just want to remind people who are participants in this project, and this is really not directed to the pro bono lawyers. We're not expecting them to have expertise in using the Home Counselor Online case management system, but that is a system that our folks will need to use, that the folks need to be registered, setting up relationships. People in your program should know what I'm talking about as I mention these things, but all of the programs need to make sure that they're getting all of that lined up. There have been some webinars that we have offered in the past couple of months about the Home Counselor Online program and setting up this project. Those webinars are available for people to view. So if they wanted a refresher or if they hadn't had a chance to see it, just let us know. We can tell you how to get to those webinars. I just want to mention, too, the materials in your book, as I mentioned at the beginning of the day today, list the contacts at the program, at the legal aid programs. And we know, and there was some discussion about that even today, that some of that may continue to need to be revised or updated. Just be sure you're looking at that and letting us know. You can let me know or letting people at the Pennsylvania Legal Aid Network know if you think something needs to be changed or updated there. I also I didn't mention this morning, but we do have a leadership team that is supported through this NeighborWorks grant that will continue to keep abreast of changes in the law and changes in programs available to homeowners, and we will be keeping all of you and others, in addition, apprised of those changes, periodically offering webinars and periodically disseminating information that will be of interest to them, and that we'll be conducting at our statewide training in the fall, in September in Harrisburg, some follow-up training to make sure that we're keeping abreast of not only changes in the law, but perhaps people who couldn't attend this training, or there's enough different. We want to make sure that we're keeping people completely up to date. I guess the only other thing I just wanted to mention to people, we are having on March 31st an excellence banquet, the Pennsylvania Legal Aid Network Excellence Banquet at the Hilton. For those who've attended it, it's an event that moves along. It doesn't, I don't think, become boring. We use videos, and in fact, one of the people being honored this year is Brian Hudson, the executive director of the Pennsylvania Housing Finance Agency, for that agency's leadership and his personal leadership in helping homeowners, especially homeowners in trouble. So we hope all of you come to our website. You can see how to find that, but we hope all of you will consider joining us for that.
Sam, then you're going to turn it back to me, and I get the pleasure of ending us all. It's sort of like a school teacher at the end of the day. At all our remote sites and here, we have one final duty for the attorneys, which is the little blue forms so you get your credits for your hours, the yellow forms for the evaluations. In Mechanicsburg, you turn them in out at the front desk as you leave. At each site, there'll be people who will make that announcement as you go. And the final point, not only to emphasize what Sam talked about with the Excellence Dinner, because the Philadelphia foreclosure program that Judge Jones, when he was President Jones, set up with Judge Rizzo, who's been getting some national press for that program, they're also going to be honored at that. So it does fit into a foreclosure training day. I want to thank Sam and I want to thank Dick McCoy for really making this work. You all don't know how much trouble it is when you have a state like ours with so many different locations, and some of them getting snow in places where, had Erie gotten the 10 inches of snow, no one would have made any calls yesterday about whether there was the training today. That it came to Philadelphia made it more of an issue. And so I appreciate all of their wonderful work. I thank all of you for coming out today, even here in Mechanicsburg where we had to deal with a little bit of weather. Our friends in Erie probably have weather that we don't even know about because they just know how to suffer through that. So let's go for the rest of the day. We look forward to working with all of you in the future, and thank you all very, very much. Take care.